education of the fourth generation. His father, late Sri D.V. Subbarao, was a leading advocate and a public figure, serving as the chairman of the Bar Council of India and the mayor of Visakhapatnam and the president of Andhra Cricket Association. Educated at Dr. L.B. College and Andhra University, Sir started his practice in Visakhapatnam, earning immense respect for his expertise and work in civil, commercial and arbitration matters. Over the years, Sir has appeared in numerous national and international arbitrations and represented major public sector undertakings, private companies and banks. Beyond law, Sir has held key leadership positions such as the President of Andhra Cricket Association, member of the Legal Committee of the BCCI, and the President of Bar Association and the Voltaire Club. And he is a trustee to several cultural and educational institutions in Visakhapatnam. Sir is also popularly named as the Swachh Bharat Ambassador of the city. In 2017, Sir was directly elevated from the bar as a judge of the High Court of Judicature at Hyderabad, directly from a Mufassil bar. And this remains the first time an advocate from Andhra Pradesh has done so. And after a distinguished tenure, Sir laid down his office in September 2023 and was subsequently designated as a senior advocate by the Supreme Court of India. So friends, please join me in welcoming Honorable Justice D.V.S. Somayajulu, a jurist who contributed immensely to the legal community.
Good morning everyone. It's my great privilege to introduce our second guest and speaker for the day, Honorable Justice U. Satya Rao sir. Justice Satya Rao sir is a district judge and the presiding officer, is a retired district judge and the presiding officer for the Land Acquisition, Rehabilitation and Resettlement Authority. Justice Satya Rao has pursued his graduation from Andhra University in the Bachelor of Commerce or BCom. He has followed the same by completing his Bachelor of Laws, LLB, also from Andhra University. As a district judge from 2010 to 2020, Justice Satya Rao has successfully adjudicated numerous cases. Testament to his lordship's dedication is achieving a remarkable 95% resolution rate through alternate forms of dispute resolution, such as arbitration and mediation. Following his judicial service, his lordship has served as the presiding officer for the Land Acquisition, Rehabilitation and Resettlement Authority from February 2021. In this critical role, he has adjudicated matters for fair compensation for land acquisition and championed dispute resolution. His lordship's efforts have led to a significant increase in the case disposal rate by at least 80%. Beyond the bench, Justice Satya Rao is also an experienced legal educator. He has shared his experience by delivering lectures and workshops for the benefits of the legal fraternity. Thank you very much, Your Lordship, and we look forward to your lecture. Please join me in extending a very warm welcome to Justice U. Satya Rao.
First witness in this case is the personal lender. Second and third witness are the attestants. Just think, what would you? Suppose there is a tape recorded cassette. Can you simply file it without saying anything into court? Saying that this is relevant for my case, therefore receive it. What are the issues that you will have to bring to a court's notice? If it is a tape recorded evidence which has a bearing on your case.
Certificate, you should get a certificate from 63.
It is a tape recording, not electronic evidence. We'll come to that in the course of the week. See, these are the little nuances that you have to, people make these mistakes. Okay? And a chief examination, bear in mind the fundamental principle, KISS. Acronym may sound bad for you. Keep it short and simple. Keep it. If you write long verbose affidavits, you are exposing your case to good cross-examination. We'll come back to this example. One lender, two attestors. We'll see how far you've understood what it is. In a cross-examination, you should go with a plan and a target in mind. First thing you should know, who is this witness? What is he speaking about? What is my case that I have to establish? What is the purpose of cross-examination?
To
test the
veracity
veracity
of
of
the
to know
Which
where
one?
discovery of
Give the other party a chance to examine.
Cross-examination.
Give the adverse party a chance to contradict the evidence that has been presented.
You are cross-examining a witness. First thing he said was testing the veracity. What is the second thing?
His standing in the society.
to discover who he is.
Standing or his
Who?
position.
Stand up. You have to talk in court also. Stand up, express yourself clearly. At best you will make a mistake, that's all. Don't worry. I went to Mr. Satya Rao also and he liked the money. I saw the man sign it, I tested it. I may be a retired judge, I may be a judge. I was just there. Good. Why can't you use cross-examination to establish your own case?
To shake his credit.
Shake his credibility, test his veracity. You can establish your own case. Suppose he gives an important admission and says, yes sir, I took the money from Mr. Satya Rao. I did not pay it. You get an answer like that, you are assured of your fees by the evening. Therefore, test the veracity, discredit the witness, establish your own case. See, in cross-examining the opponent, you not only destroy his case, you can also establish your case. We'll come back to this example a little later. It's very important. Suppose the witness admits. Suppose a plea of limitation is raised. And the witness says, no sir, that date is wrong, it is within time. Or a plea of, let us say that the person who signed the document to the lunatic, he didn't have mental capacity. Suppose the witness says, no sir, he is a very sensible man, he holds a nice job in a corporate company or he is a corporate lawyer. So to establish your case, to test the veracity, to
Discredit the witness.
discredit his testimony, etc. And what is the effect of failure to cross-examine? If a witness states something on oath, and this is a fact, and you don't cross-examine him on that, what is the effect?
We have
Presume that it
accepted,
is right.
but we have accepted that.
Sir,
Impliedly, you
Wait.
it is fatality of case. Failure to cross-examine is a common mistake made by young counsels in the courts. If you have a plan, if you plan your strategy carefully, and you go to court, you will learn this with experience. It's not as easy for both of us to talk because we have put in about 40 years today. But failure to cross-examine is fatal, not just bad, fatal. And when you cross-examine a witness, you should see what he is speaking about. Here we have two people who witnessed, attested. They can't obviously talk about the other things. If you make the mistake of cross-examining and they give some answers, some of them can prove very dangerous to you. That is why the old example of a Lord General, what not to ask, is also very critical. There should be a plan in your mind, there should be an aim in your mind, and the cross-examination should be limited to that aim. It should be brief, to the point, with the plan in mind. The issues also should be kept in mind. You should know your case like the back of your hand. The more you work on the case, the better would be the results. Now I'll ask Satya Rao to come before we do. This is on the civil side. Okay? Okay, let us go to this case. Go to the first one. Plaintiff, first civil suit for recovery of money, next. Plaintiff lent 25 lakhs on 1/10/2020. B executed a promissory note agreeing to repay with interest. Promissory note attested by Y, X and Y. Demand note is sent. Returned answer. B made a part payment of 50,000 on 1/9/23 and endorsed on the reverse. This is the plaint or the crux of the plaint. Please go. Defendant's written complete denial. Plaintiff had no financial capacity. Signature on the note is forged. Witness signatures are denied. Suit is barred by limitation. The endorsement is denied. Defendant not in Visakhapatnam on key dates. Suit to be dismissed. Go, please. That's it? Right. Now, if you go to the first slide. Yeah. Now, who will answer? Will anybody venture to prepare, say what you will introduce in evidence in this case? PW1, the first witness. What will he speak about?
That he has a capacity to send,
Okay.
to lend 25 lakhs. He did lack. But there was an
Thanks.
execution of funds.
PW1 you will say has capacity? Lend 25. 25. Okay. One capacity.
Under what section of Indian evidence? You can write that. You have taken that. What is the law of evidence that supports your contention or your defense? Whether he has such financial capacity to lend an amount of rupees 25 lakhs. What is the section of law?
Please check it while you are going through the things. We will need answers from you. The whole idea today
It's a pragmatic question. That's why
the whole idea is to prepare you.
not from
Okay? No. Please go ahead with the evidence. Somebody,
pragmatic knowledge.
Sir,
Pragmatic knowledge.
Two witnesses will introduce two witnesses.
if you are to draft an affidavit of chief of the first witness, what will you talk about? First is that he had the capacity. Then
Will introduce that promissory note,
what promise?
that lending money to these.
Okay. DP note executed. Then
The attestation is valid.
It is registered, then
did not need not register. DP note executed. Just these are the facts. With this, say what you would
so the
prepare.
demand notice.
Demand notice.
Attestation.
Huh?
Attestation.
What he forgot. I lent money. I have the capacity. I lent 25 lakhs. He executed a demand promise note. X and Y
Attestation.
attested it. Then demand notice.
Also part payment.
Part payment.
And then he made a
Part payment.
And also
50,000.
endorsement.
payment,
On endorsement.
Honor.
Endorsement.
Reverse.
endorsement.
Demand notice returned unsourced. That will reshape.
Right? So you prefer a decree with costs and interest. That's all? What is the written statement?
Complete.
Have you met anything that is mentioned in the written statement?
At denial of transaction, you can show that attesting witnesses.
Part
do-
payment also.
Part payment.
Part payment.
There is some, what is filed?
Bar and by limitation. Limitation. 3 years.
Constitution of the date.
How do you explain that it is not barred by limitation in your chief examination? There are two dates in the first.
First 2020 and 2023.
In your chief examination, you will have to state this. I lent the money on this day. Later he came and endorsed it on this day. Hence the contention that the suit is barred by time.
It is not that.
It's not bad.
What is the effect of the notice? You sent a notice, it was returned unserved. Then it is called a demand promissory note. You sent a notice. Have you read the General Clauses Act? What is the presumption? If a notice is sent by register post AD to the correct address,
That deemed to serve.
therefore you will have to write, I have sent, you don't have to say it is deemed to be served in your evidence.
Please, sir.
You will simply have to say, I have sent a notice with the address mentioned in the promissory note by register post AD. In return, cover is filed here. The judge will understand that that is a matter for argument. Okay. Then he has talked about signatures on the note being forged. Will you say anything about it in your chief examination when you know the burden is on the defendant? Do you have to say the burden is on the defendant, therefore I will not talk about it? Or what?
Presumption is
Prison.
It's evidence that you are introducing, no presumption. Evidence. Is it enough if you simply say, I lent the money, he came home, he executed the promissory note, signed it in the presence of X and Y. Will that be enough or no?
Yes.
Yes, sir.
That establishes, as far as you are concerned, that he came, he signed it. Let him come forward and then,
Prove that it's not.
therefore, in your chief examination, you will have to say how the note was executed. He met me, he wanted money, therefore I agreed to lend, therefore I lent him the money, therefore he came home, therefore he signed it in the presence of X and Y. That establishes the fact that a note was executed on a particular day. It establishes the fact that the money was received, promissory note was executed, and he signed it in the presence. So it was for him. As far as the registered notice is concerned, you can simply say it was sent to the address mentioned in the promissory note by register post AD. But he did not receive it, did not avoid it, it came back to return covers. And then he also said, defendant is not in Visakhapatnam on the key dates. Do you have to say something about that in your chief examination?
The way of executing the promissory note in the presence of testator, you have taken the money.
There are two dates. Key dates.
20, 20 and
Second is the endorsement. So what will you say in your chief examination? Whether he was present in Visakhapatnam or not? Are you expected to mention it in your chief examination?
that he
It is on him to prove that
prove
he
the
is not present.
So what will you say? How far will you go?
signature, his signature. That his
On,
signature.
he was not present in Visakhapatnam on that date. That is a corollary of history of forgery, etc. Both go together roughly most of the time. I was not there, somebody put my signature, now they are being suing me. That will be the. Again, like you talked about the,
In the signature.
simply have to say, he came, he paid me 50,000, he signed it,
Signed
and it is his handwriting on the reverse of the promise. And the burden will then shift.
To the defendant.
To the
Okay, that is why that you will have to be very careful.
owners of proof.
What about objection to marking of document? Sometimes a document which requires registration or without adequate stamp, or let's say I write a letter to Mr. Satya Rao. So I can file a copy of that letter and say, this bears my signature, this is addressed to Mr. Satya Rao. Mr. Satya Rao can say, I received this letter from Somayajulu. Both of us are competent to speak about that later. But suppose a third party's document is there. And that is important for him to prove his case.
Sections in the admissibility.
Or a document which requires stamp duty sought to be introduced in evidence.
Admissibility sections.
That is why I said stamp duty and registration act are also acts you will have to study. Particularly when a document comes to you and is likely to go into trial, check the relevant law applicable to that document. As you rightly pointed out, electronic evidence. Suppose it's a transcript or a printout. All of you. Suppose you simply introduced it to evidence without an objection. What will happen? Otherwise, what does the law prescribe? That it is produced from this machine in Rakesh working and I was in custody. Oh. Be very, very, very careful with documents. Read every document carefully. What is the law applicable to that? Stamp duty, penalty,
Registration.
the registration. If it is not registered, what is the effect? 100 rupees and more property can only be conveyed by registered document, as you all said. Suppose it is not registered? Huh?
Not outright.
Actually, is there conveyance at all? Is there a sale at all? It's useless. Not even worth the paper it is printed on. That is why you will have to be very careful with the document and the law applicable to the document. Thorough preparation is therefore, whether it is preparing a chief examiner. One mistake, it goes into record, it can cost you your entire case. And all of us have made mistakes, we are talking from experience, not as if it's something that can be taught in a class. All of us have made mistakes, learn the hard way. What you have to do, be very alert, be very cautious. Satya Rao is going to talk about witnesses and criminal, then we are going to come back to documents.
His presence brings gravitas to this discourse. Gentlemen, what do you mean by law? In the common parlance, in the parlance of a common man, I am not asking about the legal definition. What do you mean by law in the parlance of a common man? Law is nothing but experience of life. So that's why law subject plays predominant role in the society. There is a difference between layman and lawman. Words used are weapons. They come from the mint of legislature. They carry different denominations. Sometimes the same word carry different denomination. As you see, previously it is section 3 of Evidence Act, now it is section 2 of DSC, which defines
Definition.
the evidence.
Evidence.
Evidence means and includes all statements which the judge or the magistrate or the authority empowered to record your evidence requires to give. And it includes the documentary evidence also, which is necessary for the proof of a fact in an inquiry. What do you mean by the paraphrase means and includes? Why evidence means? Why they use 2 words, means, 3 words, means and includes? Why they didn't put a restriction, evidence means? Is there any object in using 3 words like a phrase means and includes? Means. This is not a cast iron definition. It brings into its sweep several facts which are not defined by Evidence Act. Sometimes something which is not defined by Evidence Act, because Evidence Act is not exhaustive, it is not complete. Sometimes the words or some definitions which are not properly dealt by evidence can also be bring within the sweep of the meaning of the evidence. So the word used is evidence means it is a cast iron definition, and you cannot bring any other thing within the ambit of evidence. But if the words used are means and includes, there is no cast iron definition, and you can bring within its sweep several other things which are not covered by the definition of evidence. First of all, I would like to impress upon you that your past performance in the college or past glory is not the criteria. Success beyond the college campus, after leaving the campus, the success after leaving the campus is the criteria. And for it, I would like to tell a small story which I borrowed from the winner. John has been working since 5 years in a company and he is a woodcutter. There was no rise in his pay, though he has been working for 5 years, no increment or no rise in his salary. Later, some bill was employed by the company and there was a rise in his salary within 1 year. John resented for it and approached the manager. Sir, I have been working in this company since 5 years. I have 5 years experience and talent. Whereas the gentleman came last year, but surprisingly and to my dismay, there was increase in his salary and his salary is more than the salary drawn by me. Then the manager said, see gentlemen, this is a commercial unit. We give salary as per the productivity. So you have been felling 3 trees per day, whereas the gentleman has been felling 5 trees per day. So naturally we have to pay more salary than what we pay to you. Then with much agony and anguish, John went to the place of his work and hit hard to fell the trees more in number, but he couldn't succeed. Again he approached the manager, sir, in spite of my best efforts, I couldn't cut more than three trees per day. What is the logic? Then manager said, I do not know the logic of John getting 5 trees cut per day bill. Then it is better we both approach Mr. Bill and inquire the reason. How come he has been cutting 5 trees per day? Then both of them went to Bill and asked the Bill, how can you cut 5 trees per day, whereas I have 5 years experience? I couldn't cut more than 3 trees per day. Then Bill said, after felling each tree, I take a rest for 2 minutes, and in those 2 minutes, I hone my axe, and again I start hitting the trees. When was the last occasion, Mr. John, you honed your axe? There is no answer and he scratched his head. Perhaps 5 years back, I honed my axe. That's why it has become blunt. And he couldn't cut more than 3 trees per day. So your past glory and past performance in the college is nothing to do when you start practice as an advocate in a court of law or when you have become a judge. A fact can be proved by 5 senses as per the Evidence Act. Am I right? What are those 5 senses? I am standing here. How can we prove? By seeing.
By seeing.
By hearing.
So a fact can be proved by seeing, by hearing, by tasting,
Testing.
by touching, by smelling also.
So, 5 senses.
So these are the 5 senses, but the 6th sense is abundant common sense. That is the core of Indian Evidence Act. Unless you have that abundant common sense as an advocate or a judge or a prosecutor or a government leader, unless you have that abundant common sense and robust ability to read the man and matters before you, the evidence placed before you as an advocate or as a judge or a public prosecutor or as a government leader, you cannot deliver the things in a right perspective. So try to read the Evidence Act not in a pejorative way, academic way. Try to read the Evidence Act in a pragmatic way, not in a dogmatic way. So what do you mean by evidence is experience of life. Forget about the definition. Then James Stephen prepared the rough draft bill way back in the year 1872, and the bill was passed as an enactment 1 of 72. Previously, in the evidence, they used it as special and several enactments, including Specific Relief Act, Contract Act, or something else in the Evidence Act itself. A schedule giving list of special enactments, and also containing some rules of evidence which are not covered by Evidence Act. And by virtue of Section 2 was deleted, so that the schedule of separate enactments were also deleted, and the rules of evidence relating to those enactments were also deleted. And thereafter, a clause was inserted to Section 2, by which Hindu law, Mohammedan law, there are separate rules of evidence governing Hindu law and Mohammedan law. Those rules were also removed. So there remains only Evidence Act. And there are certain rules of evidence in other enactments which were not disturbed by Evidence Act. What are they? May I request somebody else? The CPC, have you gone through CPC or this is first year subject or not CPC? Civil procedure.
We are reading CPC now.
So what is the provision of law, evidence, law relating to evidence in CPC and CRPC?
Same.
Have you heard about filing of written statement?
Yes.
Under what provision? Order 8 reads with filing of written statement.
Yes.
And it postulates that you have to refute
Every
or fend off all the material averments of the plaintiff. Unless you refute or fend off all the material averments of the plaintiff, it can be deemed that inspecific. It can be deemed that you have admitted those averments. Where is it? Write down. This is a rule of evidence. It can be deemed that this is an admission under what section? Indian Evidence Act. What deals with admissions? What is the section of law that deals with admissions? DSA Act. And previously, yes, previously section 17 to 21 of Evidence Act. Now they are different.
15.
So whether this is covered under admission defined in section 17 to 21? No, it is not covered. So there are certain, and take for example CRPC, BNSS. What type of, whether it is admission or confession? Why?
Because it is incriminating
Confession should be made before whom?
magistrate.
So there is a separate procedure to make a confession,
Criminal.
and it is not during course of inquiry after the registration of the crime. So this is admission. Whether Indian Evidence Act deals with this type of admission? No. Evidence Act doesn't deal with this type of admission. So these are separate rules. 313 examination in CRPC also. After recording the entire evidence, the judge is obliged to brief the succinct summary of incriminating material available against the accused. See, gentlemen, this is the evidence available to show that you have committed a particular offence. What do you say? In the 313 examination after completion of trial, the accused admitted the offence. Yes, sir. Whatever evidence is let in, it is true. I committed the offence. What type of admission it is? And Article 12 Rule 2 and Article 12 Rule 4 of CPC. Either of the party can serve a memo to the other party by saying, do you admit these particular facts under Article 12 Rule 4? And Article 12 Rule 2, they can also serve a memo stating whether you admit this particular document. Then the other side has to give a reply, yes, I admit it. What type of evidence it is? Whether Evidence Act deals with these admissions? That's why I told about in brief the history. Why Sir James Stephen has taken such a care by deleting the separate rules of evidence annexed to the schedule of separate enactments which were previously there in Indian Evidence Act before 1872. And in 1938 also there is an amendment to the Evidence Act. All these things were repealed. But the things which are there in CPC, CRPC and Hindu Marriage Act, Family Courts Act, they are not dealt with, they are left as it is. Irrespective of whatever is stated in Indian Evidence Act, all documents are admissible in matrimonial cases under Family Courts Act and Hindu Marriage Act. no stamp duty, nothing, you need not look into anything. And which demur or objection you can raise before a court under Indian Evidence Act, they have nothing to do in family court. When you prosecute a matrimonial case for divorce or for restitution of conjugal rights or for custody of a child. So these are known as formal admissions or judicial admissions. And we are being carried away by false and fallacious opinion that whatever admission is stated after taking oath before a court is known as judicial admission. That is wrong. These are the judicial admissions. Whatever admission is made in pleadings, in your pleadings, either in the plaint or in the complaint, these are known as judicial admissions. You need not take a oath. And whatever admission is made after taking a oath in court is known as extrajudicial admission or informal admission that is being dealt by Indian Evidence Act. So, judicial admissions are not being dealt by Indian Evidence Act. Extrajudicial admissions, that is any admission made by way of contract or outside court or after taking oath, they are known as extrajudicial. It takes care of those admissions and it doesn't take care of judicial admissions or formal admissions. The second one is, now there is a fact. There was a Hudud cyclone in Visakhapatnam in a particular year. How to prove this fact?
What takes judicial notice of such?
Under what section?
Section 52.
52 of BSc.
Please read it.
Rights of which court shall take judicial notice. The court shall.
There are 12 things enumerated under that section. Only those 12 things can be taken judicial notice. No other thing. Hudud Tufan is not there in that list. And there is a war in between Pakistan and India in a particular year in 1971. Because that is not there in section 52. The facts which can be taken judicial note of. There are 12 items enumerated under section 52 and you can readily take judicial notice regarding those items, 12 items. But section 51 and previously section 56, 51 of DSA Act and Old Evidence, Indian Evidence Act. So, evidence is plain, apparent and notorious. The classification of evidence is plain evidence, apparent evidence and notorious evidence. Notorious need not be taken in a pejorative way and in negative sense. Notorious means a familiar fact known to the entire country or a particular state or a particular locality. This is known as familiar fact and notorious fact. When this notorious fact can be taken note of, section 51 deals with taking of judicial notice of certain facts, 52 deals with judicial notice of certain facts. That is the difference. So, Jagadamba Junction is vehicular traffic. There will be a vehicular traffic at Jagadamba Junction in Visakhapatnam at 5 p.m. and morning at 10 p.m. How can you prove it? This is a notorious fact. And 56, you can take shelter under section 56 now, 51 of DSA. You can take shelter and you can prove, sir, this is a notorious fact. You know very well. As an advocate, when you are arguing while on legs before a judge, sir, section 56 is there. As per section 56, this is a notorious fact. Everybody knows in this locality that Jagadamba Junction, there will be a traffic jam or it will be congested with vehicular traffic at 5 p.m. And I need not prove it. So, for everything you have. And you have seen in that example, you write a plea that whether the defendant has financial capacity of lending, whether the plaintiff has financial capacity of lending such a huge amount of rupees 25 lakh under the promissory note. What are the defences available in a suit for promissory note to the other side? General defences. One is rank forgery, denying the execution of the pro note itself. The other is financial capacity of the plaintiff. The third one is, I am exempted from discharging the debt under a special enactment, Small Farmers Act, or waiver of debts. And the fourth one is discharge decree. Already I paid that amount, but it is not borne by record, and there is a receipt given by the plaintiff. And the fifth one is that he is not entitled for costs because I was not demanded. As mentioned in the promissory note, I was not served with any notice whatsoever, said to have been sent by a registered post. So he is not entitled for costs of the suit. So suppose 25 lakhs, I have to pay a court fee of rupees 30,000. So the plaintiff cannot recover 30,000 from me because I was not demanded at all. That notice not reached me. As far as plaintiff is concerned, it is enough if he says that he dispatched the notice through a reliable service of transport, that is post office, by registered post. His job is over. It is for the defendant to disprove the said fact that it has gone to the debt letters office and it was not reached to me. Where is the section of debt letters office? Again, section 16 of India. When you claim that a particular letter or a particular fact in a regular course of business is not reached to you, how can you prove it? By relying on section, first illustration to section 16 of evidence. By relying that this letter has gone to the debt letters office and it has not reached me. By obtaining a certificate from the postmaster concerned, and we can file that certificate before the court. About custom. In Telugu states, there is a custom that son-in-law shouldn't enter into the house of in-laws during Ashada Masam. Am I right? Ashada Masamlo?
Yes, sir.
Yes.
Alludu Attavaru Indiki Radaniki. How can you prove this fact? Because it is all governed by evidence. అత్తవారింటికి రావడానికి లేదని ఆషాఢ మాసంలో ఆయన ఆషాఢ మాసంలో అత్తవారింటికి వచ్చాను అంటున్నాడు. మై సన్ ఇన్ లా హ్యాస్ బీన్ క్లైమింగ్ దట్ హీ కేమ్ టు మై హౌస్ డ్యూరింగ్ ది మంత్ ఆఫ్ ఆషాఢం, which is not possible as per custom prevailing in the state of Andhra Pradesh. So how many customs are there? Caste custom, local custom, general custom, trade custom. This is a general custom prevailing in the state of Andhra Pradesh that during Ashada Masam that no son-in-law shouldn't enter into. This is being done by section
11 of the Indian Evidence and BS.
Previously it is by section 13. You are precluded from claiming subsequently that rate of interest when the defendant comes heavily stating that it is a loan taken for family expenses, to meet family expenses, and it is not borrowed for business purpose. So, unless you plead in the plaint, sir, I lent this amount to give a financial assistance to the defendant to an interest act, which generally says that you cannot claim more than 18% of interest. So, these are the various facets we have to consider before reading the Indian Evidence Act and to understand it in a pragmatic way. So how many types of evidences are there? I am not asking kinds, types. Evidence Act is classified as oral evidence,
Documentary evidence.
oral evidence, documentary evidence,
Electronic
document. So another anomaly is the Evidence Act old section 2, evidence is amended. The definition of evidence is amended after the advent of IT Act, Information and Technology Act 2000, if I remember correct, subject to correction.
2000.
So, evidence includes both documentary evidence and oral evidence, including electronic and digital record. But the word document is not amended. The definition of document is not amended. For 23 long years, as a judge, as an advocate, we have gone through and carried away only by the amended definition of section evidence and not by the definition of document. Because in the document, the word digital or electronic evidence was not there before 2023, BSA Act. In the BSA Act, they have taken care of by introducing electronic and digital. So they also amended the definition of document for the first time in BSA Act. So documentary evidence and oral evidence. I will show another evidence. There is an inscription just before your university, DSNLU, National Law University. And that is in dispute. No, there is no such inscription at all. And this law university is not christened as DSNLU. And there was no metallic or stone inscription. And the fact and issue is whether there is such inscription on any metal, whether it is stone or something else. How to bring it? You are saying documentary and oral. Whether that inscription comes under the definition of a document. If so, how can you produce that document before the court? You can't bring it. You can't unearth it and place before the court. Am I right?
Yes.
So document must be primary document, primary evidence and secondary evidence. And the primary evidence is available, you cannot play with the secondary.
Suppose it's an inscription on stone in a temple. It becomes important. Is this inscription on a stone a document at all?
Illustration.
So here some inscription is there on a matter. That is a document.
Intended to be used, or which may be used for the purpose of recording
It
the
is more lucid to you. There is a case that somebody lost his hand and his hand was amputated in an accident. It is what type of evidence producing that man before the court, what type of evidence it is.
Forensic.
So you have filed a petition for compensation against the insurer and the owner of the bus. And assume for a moment you yourself met with an accident and your hand was amputated in the accident, and you have to prove that you are entitled for compensation for the rash and negligent driving of the vehicle, and consequently it hit you and you sustained a loss. And it is a permanent disability and it comes in the way of your earnings. So your earnings were marginalized due to the amputation of your hand, or your skill was marginalized due to the amputation of your hand. Then what type of evidence it is? Producing that man who met with an accident before the court, whether it is oral evidence or documentary evidence or some other third category of evidence. If so, why it was not included in Indian Evidence Act? This is real evidence. This is a real evidence. Take for example, I insulted a judge while the proceedings are being conducted. You judge, you don't know anything. And you cannot render justice.
Speaking the truth is not a crime, sir.
So insulted the judge, it amounts to contempt of court. What type of evidence is it? The judge recorded the demeanor of the witness or demeanor of the advocate or the demeanor of the person who scolded him. What type of evidence it is and under what section it is governed. This is also a real evidence which is not covered by Evidence Act. But Sir James Stephen has given his thoughtful consideration for omitting it, and he says that even for producing a real evidence, some human agency is required. Suppose if the inscription is there on the metal at the front of your university, you have to appoint a commissioner and to see whether that inscription is there, or you have to take a photograph of it and produce it, and the maker of that photograph must be examined before the court. So some human agency is required to prove the real evidence, and that's why it comes under oral evidence, that is section 60 previously in Indian Evidence Act, and it is something in DSA Act. So you need not include this real evidence separately in the definition of evidence, and that's why it is omitted. Demeanor of the witness. Suppose he is not trying to answer the question by giving a rational answer. He is trying to go by giving a skewed information, or he is trying to skirt away from answering the question. So the judge observed his demeanor. Then what the judge has to do? So the witness is intentionally avoiding to answer the question, and he has been skirting away to answer the question. Then what the judge must do? The advocate requested, sir, you observed the demeanor of the witness.
What should you do and what should the judge do?
Yeah. If you are an advocate, what you will do?
Bring to the notice of the judge. The judge must record.
Under what section of law the judge has to record, and whether you urge about the section of law, and if so, what is that section of law you urge as an advocate, asking the magistrate or the judge to record the demeanor of the witness, either on civil side or on criminal side. On civil side, order 18, rule 12 is there. So when the witness has been avoiding to answer the question repeatedly, and in spite of questioning him 10 times, he is not answering, then the advocate, by invoking the provisions of order 18, rule 12, urges the judge, sir, this is the way the witness behaves. This is the demeanor of the witness. You please make a note of it, and you can ask him. And the judge has to reduce it in writing under order 18, rule 12, as far as civil side is concerned. What is the section of law on criminal side? CRPC 280, and now it is 350 now BNSS Act. Under section 315 of BNSS Act, you can ask the judge to record the demeanor of the witness.
This is section 12 of DSA.
So this is an election case.
Demeanor of a witness becomes important to be noted when you are arguing an appeal also. A trial court judge has the benefit of noting the demeanor of a witness. Suppose you are an appellate court advocate. If the trial court lawyer took care to note what sir has just pointed out, this will be helpful for you in arguing the appeal also. Because the trial court judge who saw the demeanor and noted that the witness is not answering properly. This will be very useful in appeals.
And what are the kinds of witnesses? This is crucial, because by and large the legal work depends upon recording, producing evidence, recording of evidence, and appreciation of evidence. That's all, the three. It is the synthesis of all these three things. So you have to produce the evidence on behalf of your client as advocates, and the judge has to record it, and the judge has to analyze it, provided it is properly submitted by the court officer. Who is the court officer? I am the judge, I am the presiding officer of the court. Who is the court officer? Advocates are the court officers. You know? Advocates are the court officers. The three stakeholders are the presiding officer of the court officer of the court, and the litigant public. They are the three stakeholders of the judicial system. So the court officer has to bring to the notice of the presiding officer the facts. So as a court officer, you are obliged to brief what type of evidence it is, what kind of evidence it is, and how can you attach some significance to his evidence, why it should be believed or why it shouldn't be believed, or why it should be disbelieved or why it should be believed. Fact, prove, disprove and not prove. So when you argue, you have to know what kind of witness he is. Suppose I was beaten by somebody else and there was abrasion and contusion on both hands. So the accused inflicted two types of injuries on my person. And I gave a report to the police. What is a report to the police and police report and complaint? What is the difference? I am saying that I gave police report and police report is reduced into writing.
Then it is an
Am I right?
Yes.
Yes.
Then it is an affair.
How? I gave police report and it is reduced into writing. Or it is taken and registered as affair. Am I right?
Yes, sir.
I drafted, so I stated in my evidence that I gave a police report, sir, and the police took an action and registered it as crime. Whether as an advocate you have to object, the word I use or the judge must use. Report to police is a report given setting the law into motion by giving a report in writing to the police. Police report means charge sheet. Am I right?
Yes, sir.
And complaint means it is neither report to given police nor a police report. It is an application submitted to the court to initiate or to set the law into motion. That's why I told that words carry different denominations. They come from the wind of legislature. You must be very careful in using the words. Okay. So I sustained two injuries and I gave evidence. What is the kind of evidence and how come I will be classified? What is the kind of evidence I given and what is the nature of the witness? How I am called? So I am called as injured witness. So the kinds of witnesses are independent witness, direct witness, interested witness, inimical witness, hostile witness, injured witness, sterling witness. This is first time Supreme Court coined this word. It is not there in the Evidence Act. Sterling witness, child witness, deaf witness, dumb witness, punch witness, decoy witness, trap witness, police witness, stock witness, chance witness, partisan witness. Then when you say that I am injured witness, can you say that I am interested witness? Being injured, I am interested in protecting my case. Am I right? So there is a probability of giving evidence with strong likes and dislikes. And there is also a probability of overstating the facts. Am I right?
Yes.
Because I am the injured, I am interested in this case. I am known as injured witness as well as interested witness. Then what the judge should do and what the advocate arguing on behalf of the defense, the accused, should canvass across the bench. You are the advocate defending the accused. I filed a complaint. Sir, this accused inflicted 2 injuries on my person. One is abrasion and the other is contusion. And please punish him for committing an offence punishable under section 323 of IPC. So my prosecutor argued, sir, he produced a wound certificate and I also examined witnesses who are there, and his evidence is believable, and you please punish him, and his evidence is tested on the anvil of test of truth and it should be a test of cross-examination. There is no improbability whatsoever elicited during the cross-examination. Last occasion his lordship asked, what do you mean by cross-examination? What do you mean by cross-examination?
Examination by the
What is
advocate.
the object of cross-examination?
To test the veracity, to discredit the witness.
All these things come as and collectively known as to elicit the truth or falsity of a fact in issue. After all, the object of cross-examination is to elicit the truth or falsity of a fact in issue. So you can examine a witness and cross-examine a witness, and you can shatter the evidence of a witness regarding material aspects. Suppose during my cross-examination, I was questioned who were present at the time of the alleged incident. I stated that I am present at my house. The inmates of my house are also there, and my neighbor is there. But in this case, there is no neighbor, and a person who is a passerby is cited as a witness.
Independent witness.
And that person gave evidence. What kind of evidence it is, and what is known as, what kind of witness he is? A passerby.
Chance witness.
Yes.
Chance witness.
What is the
Chance witness.
veracity of the evidence of that witness?
More weightage.
So there are 19 kinds of witnesses or 20 kinds of witnesses. So if you say that interested witness or my relative, my brother came and gave evidence supporting my version.
Interested.
My wife came and gave evidence supporting my version.
Interested.
They are interested witnesses. And the chance witness passerby is also examined and he gave evidence. How to appreciate these types of evidence? The advocate for the accused argued, sir, they are highly interested witnesses because the PW2 is no other than the wife of the injured. PW3 is no other than the consignment brother of the injured. And PW4 is a chance witness whose presence is improbable and can be doubted. So, how can you rely on those evidence? There is no independent witness is examined. So, independent witness is one kind of witness. He excluded the independent. But the prosecutor argued that it is not the label that is to be looked into, sir.
It is about the
It
statement
is
he made.
the evidence that is to be looked into. So the court has to see the veracity of the witness. Complaint I depicted that the accused became all of a sudden and intruded into my house and inflicted injury with a bamboo stick on my head. My brother stated the same thing, my wife stated the same thing, and the chance witness also stated the same thing.
Corroboration.
Can you discard the evidence, or can you serve the evidence of a witness on the mere ground that they are labelled as interested witness, chance witness, or partisan witness? No. When the evidence inspires confidence or it instills confidence, you cannot spurn the evidence of a witness on the mere ground that he is interested witness or a partisan witness or a chance witness. What is the difference between interested witness inimical witness and partisan witness. What do you say, partisan witness? Inimical witness, you know, because he is enemy to me and I am the accused, so he deposed against me. What is partisan witness? Partisan witness means there need not be any enmity in between the accused and the witness. And also there need not be any acquaintance between the complainant and the witness. And there need not be any interest in the complaint as far as the partisan witness is concerned. But somehow the witness doesn't like the accused. He states that he belongs to Congress party. Though this gentleman doesn't belong to any political affiliation, he has a strong dislike towards Congress party. He comes and deposes. So, sir, this gentleman bet the so and so. So there is no enmity between the accused and this gentleman. There is no acquaintance in between the injured person and this gentleman. He is totally independent witness, but still he is a partisan witness because it was elicited in the cross-examination that he has a great condemnation towards a particular party. Since the accused is a strong supporter of Congress party, he deposed with strong likes and dislikes before the court. So the propensities, preponderances and the prejudices with which they have deposited the evidence, that should be calculated. That should be taken into consideration while appreciating the evidence of a witness. Child witness. Child witness said something. What are the precautions to be taken into consideration while appreciating the evidence of a child witness? Children often believe in the world of a make-believe. Somebody came and rushed intruded into the house and he beat me with a stick. The mother said to the child 10 times, though the child is not an eyewitness or a direct witness, there is a tendency of making believe the child that something has happened yesterday night and some stranger came and intruded into the house and beat my mother. So this make-believe theory, children are often prone to this make-believe theory and the judge must be careful in assessing the evidence. What are the steps to be taken in case of recording the evidence of a child witness? So a boy of 10 years was produced before the court as a witness. How to record his evidence?
Both cannot be taken.
So you can take both, there is no problem. First of all, what are your parents and what is your name and what is the name of your classmates? What was the food you have eaten yesterday? What was cooked today? So the boy gives some rational answers to these informal questions. And where are you now? Say, the boy said that I am in court. Who are they? Sit all along. They are the advocates. Who am I? You are a judge. When you get some rational answers, you can resort to record his evidence. So before that, you make an observation that I made myself sure as a judge that I put some informal questions to this witness and I am thoroughly satisfied that he gave rational answers and he has a capacity to depose before the court. So after recording these things, you can resort to reduce the evidence of the child witness into writing. Suppose if he fails to give rational answers, then you must make a note of it and say that there is no comprehensive idea about the things as seen from the answers given by the child witness. So I am skeptic about his competency to depose evidence and then you record the evidence. So there is a leeway either to the defense counsel or to the prosecutor to argue in favor of the prosecution or against the defense, and it is for the judge to see at the time of appreciating the evidence how to believe the evidence of this child witness. Deaf and dumb witnesses. You have to take the aid of the expert people who are familiar with the language code of deaf and dumb people. Choted witness. Who is this choted witness?
Advocates.
Every second witness is a tutor.
Choted witness. Suppose before the advocates generally put a question during the cross examination, the court constable met you and told you about this offence. And what is the statement you have given 4 years back? Yes, he says that yes, I am briefed about the statement I have given 4 years back. Have you gone through the statements that have been given by you before the police? Yes, I read. The police constable gave it to me, and just 1 hour before I came here. So whether this admission would take away the efficacy of the evidence of the witness? Simply because he stated those things which are quite normal outside the court. Can the judge or the advocate argue that this witness cannot be relied upon? The evidence stated by him cannot be taken into consideration. No, these are trivial things which do not impact the trustworthiness of a witness. Only the things that impact the trustworthiness of the witness are when he recites from the material facts. When the witness goes away, far away, and gives a different version regarding the topography of the incident. Sir, I was very much present. Previously we discussed about a chance witness. Just to confine him, sir, where is the house of the complainant? He gave a different picture about the location of the house of the complainant. The topography. What is situated beside the house of the complainant? And how many inmates are there by the time you witnessed the offence in the house of the complainant? He gave different versions. When his evidence is read with the evidence given by the complainant, there is totally a divergence regarding the material aspects. In depicting the scene of offence, in the picturization of the scene of offence, or in the material facts that my wife is not there by that time, my son is there. He says that he is overstating the facts. So this material discrepancy, whether it goes to the root of the case, that is to be appreciated by the judge, and that is to be argued by the prosecutor as well as the defense counsel in appreciating the evidence. Then what is this sterling witness? This is unknown to Evidence Act. This is coined by the Supreme Court way back in the year 2016 or so. Have you heard about a sterling witness? Sterling witness means highly qualified and highly trustworthy witness. So, there was a case, Santosh Prasad versus State of Bihar. In this case, the wife gave a report stating that the brother of her husband ravished her, raped her. And there was a delay of 15 days in giving the report to the police. The witnesses examined are the inmates of the house. And all the witnesses didn't support the case of the woman. She is the only witness who clung to the evidence given by her, the report given by her, by depicting all the material aspects. Then the trial court convicted the accused, imposing a sentence of 10 years. Then the matter went to the High Court. High Court also convicted the accused because the sole testimony of a rape victim is enough to convict the accused. Then the matter went to the Supreme Court. There they used the word sterling witness, which is previously used 3 years back before pronouncing the judgment. When the sole testimony of the rape victim is sufficient, it is free from any discrepancies, contradictions or inconsistencies regarding material aspects, the court can term that witness as sterling witness and it can rely there is nothing wrong. But in this case, even the doctor who was examined on behalf of the prosecution didn't support the case because the semen collected from the petticoat of the victim is not conclusive and it is not sufficient to determine whether it belongs to the accused or not. In such a case, when there is nobody supported the evidence of a witness and the witness evidence of the rape victim itself suffers from the vice of inconsistencies, material contradictions relating to the incident, then how can you rely upon the evidence of the rape victim? So, it is not an yardstick that when rape victim says with full throat cries that she is ravished, you have to convict the accused. But you have to analyze it and appreciate the evidence by taking into consideration the backdrop of the situation as well as the evidences of other witnesses. Accused witness. What is the section of law that enables an accused to give evidence on him, tender himself as a witness?
Yes, sir.
So what is the section of law?
So 125 section gives it allows everybody to testify.
BNSS.
DSL 124.
Who may test?
So if that is so,
CRPC that enables the accused to tender himself as a witness with the leave of the court. He must take the leave of the court and he can tender himself as a witness and he can do. All the witnesses are examined, but the investigating officer was not examined. The material on record is sufficient and the witnesses withstood the test of cross-examination. But surprisingly, the defense counsel raised a plea, sir, in this case the investigating officer is not examined. Investigation is nothing but collection of evidence. And when I am deprived of the opportunity, how come he collected the evidence relating to the prosecution case and to put the contradictions or omissions elicited in the cross-examination of witnesses to the investigating officer for double confirmation as per law, how can you convict the accused? This is the argument rendered by the accused counsel. The prosecutor argued that there is no hard and fast rule that in each and every case the investigating officer should necessarily be examined. The non-examination of the investigating officer doesn't come in the way of rendering substantive justice. The investigation officer died or he has gone to a place where he cannot easily be reached.
Section 26.
So he has been living in states, it is not possible to bring him at the nearest point of time. So in such a case, you can rely upon the evidence available on record, and the evidence available on record inspires confidence or instills confidence, then you can convict the accused. Trap witness. Have you heard trap witness?
Yes.
Who is the trap witness? It is day and night. It is a perennial problem of ACB people and CBI people and vigilance people. So, a particular officer demanded for a bribe. So, then how to pardon him with the liability of corruption? How to pardon? Then you will set up a
Trap.
witness to trap that officer who is not supposed to take bribe. Then the trap witness will go and offer bribe as demanded by the, and along with the trap witness there will be police personnel in informal dress, not formal dress, lingering, wandering here and there. The moment the trap witness gives a signal by showing a handkerchief or by just giving a missed call, they will come inside and they will catch the person. So this person is known as trap witness. And unlike in all other cases, FIR will not be registered very soon after giving a report that a particular gentleman has been insisting me bribe. The FIR will be registered only after the trap witnesses confirms it. Evidence of approval, accomplished. How do you read it? So I said, it is not the label. It is not the kind of witness that disables him to give evidence, and that the court cannot read the label of the witness before appreciating the evidence. The court must maintain a neutral stance. It shouldn't be carried away. Your IQ shouldn't provide over your emotional quotient shouldn't provide over your IQ. So prosecutor argues emotionally, accused argues emotionally, but the judge must maintain a neutral stance. He cannot be carried away by emotional quotient. There must be some coordination between emotional quotient and intelligence. He must sit calmly and read the evidence. When there is some doubt in the evidence, then he can take the aid of the label. Oh, he is an interested witness. He is a stock witness. He is a trap witness. So this is not wise to believe his evidence. Suppose if there is some circumstance elicited in the cross-examination to doubt the veracity of the witness. Till then, you cannot pick up the label. Being a judge, you are not supposed to rely on the label. I filed a complaint stating that I was beaten and I sustained a head injury. I was hit by a bamboo stick. So the doctor recorded my statement and also the weapon used in inflicting the injury. Then I stated before the court while giving evidence that he beat me by coming in front of me and inflicted head injury, and there are stitches to my injury. Whereas the doctor said that I was questioning about the length of injury and the direction of the injury. The direction of injury, length of injury. The doctor gave a certificate that no injury at all. In second case, the doctor gave a certificate that there is injury. The length is like this, the direction is like this. In third case, he stated that there is injury, but it is not head, but on the hand. How to appreciate this evidence? In first case, the doctor didn't support my case. In second case, suppose if the doctor assume for a moment, the doctor supported my case to some extent, and there is a discrepancy regarding length and direction of injury sustained by me. So the ocular evidence is different, eyewitness evidence is different from the medical or expert opinion. And in third case, the limb is different. I stated that it is on hand, the doctor stated that it is on hand. How do you appreciate? These are the practical things you face in court of law, you encounter in court of law. As a prosecutor, how can you argue? As a defense advocate, how can you argue? As a prosecutor, you can say that medical certificate is not essential because ocular evidence prevails over medical evidence. But when the doctor examines and you stated that you are examined by a doctor and gives a certificate that there is no injury at all, it goes to the very root of the case. And the judge must be very careful in analyzing the evidence and he shouldn't hesitate to acquit the accused. In second case, there is discrepancy regarding the direction and measurements of the injury. It doesn't take away the credibility of the witness. So some minor discrepancies or for that matter material discrepancies in regarding the direction and the measurements do not take away the evidence of ocular witness. Ocular evidence prevails over medical evidence. That is the general rule. When eyewitnesses evidence prevails over the opinion evidence of a doctor. In the third case, the limb is different. Then the judge must be careful. This is decided in Taman Kumar versus State of Duty of Chandigarh, 2003, Part 6, Supreme Court cases 380. So you will be encountered with these types of things. Last time you Lordship posed a question. 25 lakhs you have no financial capacity. What is the section of law wherever you can take such a plea? The plaintiff has no financial capacity of lending rupees 25 lakhs to the defendant. Defendant took a plea in the request statement. Sir, he is middle class, middle income group person. He has no such capacity to lend 25 lakhs to me. That is the defense statement and dropped the written statement. And under what section that plea is maintained? Section 11 of when things not relevant are relevant. Say, this son, I am not the legitimate father of this son. I didn't sign this pronoun because I am illiterate. I am a marksman. I do not know how to sign. Previously there are documents and a plea of LB. Not only section 11 deals not only with plea of LB, it deals with several things. That when you plea that you have no capacity to lend such huge amount, the plaintiff has no capacity. Bear in mind it is section 11. When things not relevant are otherwise relevant. And when you say that you are not competent to procure, when you say that you deny the signature, I am a layman and a marksman, I am not a literate and illiterate, you can take a plea under section 11 of Evidence Act. So these are the pleas available. So this is only one part regarding pragmatic approach that should be adopted in courts. Question the complainant or witness. What is the color of the shirt that was worn by the accused on a particular day? He said that it is red shirt. The injured said that it is white shirt. Definitely there is a contradiction because the previous statements are recorded. In the previous statements the complainant stated that he wore white shirt, whereas the witness said that it is red shirt, or the complainant himself said that it is red shirt. And that statement, by drawing his attention under section 145 of Evidence Act, that statement is marked as contradiction. So while arguing the case, the accused said that this contradiction improbabilizes the version of the prosecution. Whether this contradiction goes to the root of the case, or can it be treated as a minor contradiction which has no impact whatsoever on the case of the prosecution. This is a minor contradiction because by and large, the observation capacity depends upon the focus at the time of incident. Some may see the wearing of dress, some may see how he bed the witness, some may see how he snatched the cell phone from, and some may see how fast the motorcycle was driven. He rode the motorcycle in a fast and negligent way. Some may see that he wore a beautiful shirt. So by and large, this depends upon observation capacity of a witness, and trivial discrepancies or contradictions do not take away the efficacy of the evidence of a witness. These are the general rules which you do not find in Evidence Act, and you can find it in commentary. So please go through the commentaries and have a pragmatic knowledge.
Brief. Now we have this example here. Row 4. How will you, if you are a counsel, no capacity to lend 25 lakh rupees, plaintiff is sitting in the witness box, the entire row, you can answer.
The occupation of the plaintiff, what he is doing in the court.
You're not discussing it.
Bank account details of the plaintiff. Submit the bank account details of the plaintiff.
How would you question him? You are a counsel cross-examining a plaintiff who says he has lent you 25 lakh rupees and now you say he doesn't have the capacity. What would be your first question? So I can lend 25. You don't need monthly income. You have a rich father. First question would be, what is your capacity to lend 25 lakh? First question you should have, where did you get the 25 lakhs from? Did you withdraw it from a bank? Under the Income Tax Act, there is a limit. Okay, that's for final nuances. First question should be to attack him on his financial capacity to lend 25 lakh. So the source of the money becomes important. First question should be, where did you draw the money from? How did you get 25 lakhs rupees? Even more, suppose you ask your client, investigate his background. Suppose this fellow filed an insolvency petition. He declared an insolvent. You can confront him. You are declared an insolvent by the court. Therefore, you didn't have the capacity to lend.
25 lakhs.
That is how you should attack the witness.
Can
Say
summon
it.
the banker also for
Yeah.
cash production of his bank?
If he says there is a bank, what will you do? Like sir said, which branch? Do you remember your SBI account number? Summon that. That shows there is only 5 lakhs. Disclose his case on that day. Okay, row 2. Signature on the note forged. What would you do? How would you prove examining counsel?
So we will ask for the signature is specified and we will tally it with
What idea you do?
So where the signatures are mentioned in the government documents.
Is that proof?
It can.
My signature will vary with age, with time. So it is your duty to prove that the signature on the promissory note is forged. What would you do?
I would say
Is
that
there any provision in the Evidence Act that enables you to
Forensic evidence, section 39.
expert evidence?
Section
Handwriting
39. Expert.
experts. Okay.
Section 39 to what?
Thank you. Is there any other way of proving it?
Section 65.
When a person comes to court,
court may ask him to give his writing specimens.
specimen signatures, then should the court compare it or should the expert compare it?
The court has three different
The
options.
gentleman's signature.
If you are
Moreover,
I am acquainted with the signature. This is a signature, sir. Will that be accepted by a court?
Familiar evidence, what we call as familiar evidence.
Is there any other simple way?
sir, attested witness.
Just your signature is forged. That's the limit. When you enter the court, what are the documents that you normally sign and give your lawyer?
Vakal.
Okay. Then you will file a,
Vakal.
you are a defendant. File a
Written
written
statement.
statement. You might also file an affidavit. Now, your signatures are there in court. Can they be used?
Yes, sir.
That is another method. Signatures which are normally made in the course of regular law are available in court. So will you use that or will the other side use it? You can show it. This is my normal signature. Suppose the other side says, with that idea in mind you change your signature, then it is possible. In life you are going to encounter so many of these theories that both of us are talking about are from our real life experiences.
Sir, bringing
Even
to
I
the
Client,
public
the
record.
clients are smarter than the lawyers, most of the time.
Experts have been insisting for contemporaneous
Yes.
signatures because due to the afflux of time and years, there may be variation in the stroke of your signature. So even the experts have been insisting for contemporaneous signatures and authenticated signatures. Suppose you executed a sale deed or you executed some other documents and the defendant can produce the document and place it before the court. And this is the signature and this is authenticated signature because it is executed in subregistrar office after making the identity established.
So you have an expert, you have contemporaneous signatures, you have signatures available on the court record, and you have people who are acquainted with the signature. You are a counsel.
Like the flight tickets or...
So a flight ticket, I can book a flight ticket and file a flight ticket and not travel.
Plea of alibi.
Plea of alibi.
Plea of alibi.
I want to know. I'm just interested in knowing, that's all. You have to cross-examine. How will you prove? You have a flight ticket and a boarding pass. Then you must be staying. If you are on an official trip, you must be in a hotel. Or any other method.
Sir, CCTV camera.
Suppose you are in another city and you execute a document on that day.
That becomes.
And
This is how you will have to think.
CCTV cameras.
You will have to get authentic evidence to show sequence of events should establish that you got a flight ticket, you travelled by the flight, you checked into a hotel, you did the following acts. Therefore, this proves that I am not. I had a case when I had to grant a bail. Man was accused of SC/ST Act. On a particular day, he met a woman and abused her by the name of caste. The only thing that the lawyer did was he filed his passport in the court. Schengen visa. Entry, exit, entry, exit. Within the 7 days that he was supposed to be in the Guntur area, you will not have merely to prove an air ticket, boarding pass, stay. A sequence of events should be established to show that you were not just one. You never know which question will hit home. You never know which question will impress the judge. What you think would be your strongest point may end up to be dismissed by the judge. What you think would be the weakest point may score with the judge. Therefore, always keep your options open. Barred by limitation. How would you prove it?
So plaintiff maintains records.
I'm not asking for a description.
In promissory notes.
Does limitation have to be proved? Or if it is available from the records, can it be argued and a finding invited?
On which date he parted from the money, like 50,000?
Your case is the suit is barred by time.
1/9/2023 and it's not after 1/11/2023.
That is the plaintiff's case. Defendant's case it is barred by time.
The endorsement was forged.
How do you? You are on a question of proof. If you are a counsel, you are arguing. In your cases, my client says that the case is barred by time. Therefore, dismiss the suit as your claim. How do you?
Proof of alibi that on the day the endorsement was marked, I was not present at the place.
Okay. Therefore, what happens?
So the endorsement was forged and hence the limitation, extension of limitation by virtue of the endorsement being made on that day doesn't exist. So limitation, it is
Therefore,
barred.
you will have to again establish
The force.
1, 2 and 3 leading to a conclusion. Suppose it is visible from the record. Without that, the suit is barred by time. Do you have to prove it or does the judge by himself can dismiss it? Have you read your limitation act?
Yes,
Reading it.
Read. Not understood.
two
Section. Do you remember what section 3 of the limitation act says?
Yes.
What does it say?
Bar limitation.
That's all. You're going to be practitioners. You don't need to know the headings. You need to know the content. Section 3. Read it out loudly, somebody.
Bar of limitation. Subject to provisions contained in section 4 to 24, inclusive. Every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense.
Although
The
limitation has not been set up. Which implies
the court
that it is the duty of the court. So as a counsel, your duty is to point out, even if I did not plead it, the suit because of A, B, C reasons is barred by time. You have a right, you must dismiss it. It need not be. Suppose that endorsement, as he rightly said, is not proved, it goes to that. Even if that endorsement issue is not there, none of the suit. Where you read the plaint and you find it, but you can simply see. Okay? Any questions and answers? Any questions for answers?
He asked that 50,000, I have already taken a plea that I paid 50,000. How can I take a plea that the signature doesn't belong to me? You can take any number of inconsistent pleas. I can take a plea that the signature doesn't belong to me, and I can also take a plea that I discharged the debt, and I can also take a plea that I made part payment, and I can also take a plea that I am not liable. Any inconsistent pleas can be taken on civil side by one person as a defense. You can take all the pleas, but you have to prove it.
There is a class coming on evidence on request. If you are interested, otherwise. Third row. Which year are you in?
First.
In the first year? No wonder you were bored. That row there also was bored. Okay. The The idea behind this and inviting Satya Rao and others is to have practical aspects of law. Some students have requested us, requests have reached us. So if you are still interested, please let us know. Otherwise, both of us have our own life to lead, our own things to do. We are here only out of our interest in helping the students, nothing more. There was a request for IBC, NC, which is third year or fourth year?
Yes.
We've identified somebody for pleadings and conveyancing. Only the practical aspects. Satya Rao is also available. Anything to do with criminal law, civil law also is very good. Criminal law will be even more interesting because his personal experiences in judging thousands of cases. He is also here, he is stationed in Visakhapatnam. It's for you to make. I had a lot of friends in the National Law School, Bangalore. Some of their best experiences were people like Ram Jatmalani and all coming and talking after Madam Gandhi's assassination. That is what triggered the idea, nothing more. So you have a very experienced district judge here. If you need anything, you can tell your dean. We have met the dean also. So sir is willing to come. If I am in Vizag, I can. Any questions, please? How to stay awake in a lecture? I don't know.
I had doubts, outside the sessions.
Outside the?
I had general doubts on the law of evidence, which I got through the course. If I could ask. So one doubt I had was that in strict laws like UAPA, in cases like UAPS, special laws like UAPA, we are seeing that there are a lot of bail matters that are pending. And in particular bail matters, what has been happening is that they are asking for the prima facie the case must be true, as said in Zahur Ahmed Shah Watani. And a kind of a mini trial is itself happening for a bail case. A trial within a trial is happening within a bail case. So how much evidence can be admitted or how much evidence should be given for a normal bail case?
Concern. The first thing you have to see the nature of the offence, whether it is grave offence or not, whether it is a heinous offence or not. The second one is that what about the formidable part of investigation done so far at the time of moving the bail application? Suppose the material witnesses, some material witnesses are examined and the remaining witnesses also speak on the same lines. You can impress the court, sir. Already 3 material witnesses are examined in this case as seen from the remand report submitted to the court by the investigating officer. So the other material witnesses have to be examined also speak in the similar way. I am not a man having political clout to influence or to suborn the evidence of a witness. I do not interfere with the investigation. And there is no flight risk. What is flight risk? There is no risk of absconding from the jurisdiction of this court. Because my length of residence in the community is very long. I have fixed abode of living, family and properties. And so for the sake of this offence, I don't leave the jurisdiction by discarding my sons, my children, my wife. So apprehension cannot be doubted. My apprehension cannot be doubted. I am always available to the police officer. As far as interfering with the investigation is concerned, I belong to a normal middle class family or a family without having any political clout, so that I do not interfere with the investigation or I do not prevail over the remaining witnesses whose statements are yet to be recorded. And the material documents are already seized by the investigating officer to connect the crime with the accused. So there remains nothing except the formality of filing charge sheet. By this way you can impress. The prima facie case not necessary in bail application. Of course, it all depends upon, I said, the judge shouldn't be carried away by emotional quotient. There should be a coordination between his IQ and EQ. You cannot, like an advocate or like a litigant public, the judge cannot be carried away by emotions, by seeing. That's why in classes, as per professional ethics also, as per ethics of judges also, the judges are asked to read the newspaper in the evening, not in the morning.
I wanted to say.
And also watch the television in the evening.
You have just said the mini trial is being conducted. Have you read any orders before you ask the question? This particular question, is it based upon any order of a court that you have information? That's all I want. I don't want to know this.
it was the repeated, it was a repeated denial of bail in some UAPA cases, sir.
That's why I'm asking you the question again. Have you read the orders passed by the concerned judge before posing the question, or are you?
In the case of Zagur Ahmed Shah Batali, given by Justice Khanvilkar, he said that prima facie evidence should be there, so we can deny the bail. Some judges use this case, whereas
Don't, like sir just told you, don't get carried away by
Social media.
social media,
Newspaper.
newspaper.